Ironically, you were already sort of in this mode, talking with your students about this, specifically focusing on reproductive rights. Let's just jump right into sort of the big barrier in this story. How could we be in a position to get two totally different messages from healthcare professionals and the Attorney General's office?
Yeah, so that's an interesting question, and I think there's a lot going on that is at play in this. So first of all, with respect to the Attorney General's statement and the decision made by the hospital, is that the Attorney General's statement came 90 plus days after the initial decision to keep Adriana on life support was made. So once that decision was made, it's hard to walk it back once the Attorney General made their statement. But even setting aside that issue, with the anti-abortion law in Georgia, so that is the first major barrier and the interpretation issues that we have going on here. So under Georgia law, under what is called the Living Infant Fairness Equality Act, or the LIFE Act, abortion is prohibited after the detection of cardiac activity, which occurs around 6 weeks gestation into the pregnancy. So at the time that Adriana had her medical episode and was declared brain dead, she was around 9 weeks pregnant, which meant that the hospital assumed that terminating her life support would also result in terminating the pregnancy, which the hospital interpreted as being an abortion under Georgia state law. So Georgia state defines abortion as various types of medical acts, including prescriptions or procedures, etc., that are done with the intent to terminate the pregnancy. So the Attorney General here is essentially saying that withdrawing or withholding life support isn't being done with the intent to terminate the pregnancy. It's being done with the intent to essentially allow natural death to occur for Adriana. The hospital, however, because of the vagueness of the law, they would view it as potentially being subsumed within that definition of abortion, because a necessary effect of withdrawing life support would be terminating the pregnancy. So part of the issue we have going on here is also the fear and the chilling effect that is going on for medical professionals. So because of the vagueness of the law, the concern is that because they didn't have this interpretation from the Attorney General at the time they had to make the decision, this is essentially a test case. This has never happened in Georgia before since the anti-abortion law was passed. And these criminal penalties come with 1 to 10 years of imprisonment. So the hospital would rather risk the potential medical malpractice that would come along, potentially with doing life-sustaining treatment against a family or patient's wishes, which would be a civil case, medical malpractice, covered by medical malpractice insurance, versus a criminal penalty, which is not covered by insurance.
Can you go deeper into the fear? There is a lot of fear that these healthcare professionals are working under because jail time is on the table.
Yes, absolutely. So it's not only, of course, when you have a civil penalty or medical malpractice, there's always the concern of fines, monetary fines, as well as potentially losing your professional license. But when you have criminal penalties in the mix, not only does that risk your professional license, that also risks jail time. And then also, once you get a criminal penalty, even a felony, that would, even if you get out of jail or you don't get imprisoned, you have that on your record forever. So this is something that is happening across the nation in states with these anti-abortion laws. So that is one thing, one wrinkle in the story. But I think another thing that hasn't been discussed enough is, even setting aside the abortion provision in Georgia's Life Act, Georgia has what is called fetal personhood. So at the point of cardiac activity being detected, that same around 6 weeks, Georgia defines that essentially it's still an embryo. It's not even a fetus at the time. It's still an embryo, but that is determined and defined as a natural person under Georgia law, which then also kicks in other types of criminal law. So the hospital could have also had in their mind that even setting aside abortion, withdrawing life support from Adriana would result in the death of the fetus, which, if that fetus is a person under the law, that kicks in potential homicide charges. So there's, again, this fetal personhood thing that even if we set aside abortion entirely, there is the potential that the hospital could have believed this could have resulted in murder charges as well.
Yeah, I'm scared too.
Yeah.
Right? Yeah.
So, and again, under Georgia's fetal personhood law, which is really one of the first in the nation to have this explicit fetal personhood for a variety of different laws, so that kicks in criminal charges. In Georgia, you're allowed to deduct your fetus from your taxes just like you would a living child. You are allowed to seek child support for a fetus. So Georgia has a pretty broad fetal personhood provision within their law, which again is another area that instills fear in healthcare providers, because a lot of this is untested and unknown how the state is going to interpret these laws.
You touched on it a little bit, but I want you to expound more on it, just about how living wills are void when it comes to a child being involved in that case.
Yeah.
So many people don't realize that I went through the proper process of, getting my affairs in order, but in this case, it could be void.
Yeah, so that's a really good point. And I do want to be clear that there's no indication that we know of that Adriana has a living will, but I think that this is a story that can maybe help bring that to light and help provide some education for people, because this is so unknown. So in the majority of states, I believe it's around 30 states, a pregnant person's living will is essentially void or suspended through the entire pregnancy or at certain points in pregnancy. So in Georgia, a living will, if a woman who is going to be pregnant or is already pregnant has a living will, there is this area on the living will document where you have to explicitly initial to say that if I am pregnant, I want my living will to remain in effect prior to viability. So if you don't check that box and you get pregnant, then your living will is void during the entire pregnancy. But even if you check that box, once the pregnancy reaches viability, which is around 24 weeks, that living will is suspended regardless of what you indicate. So at this point, let's assume Adriana had a living will, and let's assume she said that she wanted her living will to remain in effect during pregnancy. She's around 22, 23 weeks, so that's very close to the time when that living will would have no effect anyways. And in other states, like Texas, for example, your living will is void from the moment you know that you're pregnant, from the moment of conception, essentially. And again, this is something that I think most people are not aware of. Again, as you said, you can think you have everything in order, but this is something that is so under-discussed that I think the law needs to be better about educating people, and I think healthcare providers also need to be better about educating their patients who are considering pregnancy or already pregnant, because this is something that they need to be aware of, that their wishes may not be abided by.
What sort of legal precedent do you think this case has set in our state?
So thus far, it hasn't set exactly a legal precedent as well. I think we are still seeing kind of the shockwaves and that's the problem, is that it's necessarily not setting a legal precedent. So it's still not giving the right answers to people. If today, for example, another pregnant person ends up in Adriana's situation, I think it's still a little bit unclear as to what a hospital and what medical providers might have to do depending on the point of pregnancy. So I think the Attorney General's statement would give hospitals a decent amount of comfort to, prior to viability, not sustain life. But again, that's only with respect to the abortion law. The Attorney General didn't answer the question about the fetal personhood law. So the Attorney General said the abortion provision doesn't prohibit this, but it said nothing about the fact that that fetus is a person under the law. So what does that mean for the homicide laws in Georgia? So I think there's still a whole host of unanswered questions that it's on the legislature at this point. It's on the legislature, it's on the Attorney General. They need to give providers answers, because I think it's very easy to criticize and maybe fault the hospitals and the medical providers in this situation, but I don't think that's the right answer. They were really in a rock and a hard place. Again, they had the decision to make between withdrawing, withholding support, potential criminal liabilities, potential malpractice. And again, this chilling effect on healthcare providers is pervasive throughout the country right now. And they should not be expected to be lawyers at the bedside. And we also can't expect professionals, healthcare professionals, to have to get answers on a piecemeal basis. This was not the right situation for them to be in. They shouldn't have had to wait 90 days to get an answer from the Attorney General. This should have been clear, so laws need to be amended. More clarity needs to be given to healthcare providers.